Hello everyone, and thank you for joining us for Secrest, Wardle, My PIP Monthly September 28 edition. My name is Javon David, and I'll be joined today by my colleague, Aleasha Hester, who will talk to you about trending topics in PIP litigation. This month's podcast will go through some case law that came out in the Court of Appeals. There was a total of 5 cases, but truly 3 of those cases were a provider decision that kind of analyzed covenant and showed the court's current application of covenant. I'll go through these cases for you, and my colleague Aleasha Hester will then talk to you about trending topics in PIP litigation pertaining to fraud and using your fraud toolbox, different things to investigate while you are looking at a claim and there's suspicious information that arises, or you uncover something that causes you to want to get either SIU involved or conduct some of your own fraud investigations pre-suit. Now, the Court of Appeals issued a handful of decisions in PIP law today. I'll go through those today. All of those cases are unpublished, but they're still important to your understanding of how the courts are applying Michigan case law and also how they factor into the handling of your day-to-day claims. The cases, although they're not binding, they do serve as persuasive to the trial court when you are handling a claim and when you're arguing a motion for summary disposition and you argue to the judge, this issue has been analyzed. This is how the Court of Appeals is addressing this issue. So keep that in mind as we go through these unpublished decisions. Now, the first case from the Court of Appeals this month is the Pitts versus State Farm automobile case. In that case, the plaintiff Pitts and the intervening plaintiff, Aleasha Zamorano, each appealed the trial court's order granting summary disposition to State Auto. The lawsuit arose out of a rear-end accident that occurred on December 21, 2013. Pitts rear-ended a vehicle, and after the impact, the rear of his vehicle struck a utility pole. He submitted an application for no-fault benefits. In the lawsuit that was ultimately filed, there was an intervening provider that was Dr. Zamorano, who intervened to recover PIP benefits for medical services provided to Pitts for his injury sustained in the accident. Now, State Auto asserted that Pitts made the following 3 false representations in his application for benefits. Number 1, they argued that his vehicle was stopped when the accident occurred, contrary to what he had stated. And number 2, that he had not received medical treatment in the past for the same or similar conditions, which his medical records revealed otherwise. And finally, number 3, that he had not previously received either workers' compensation or Social Security benefits. Again, Pitts admitted during the course of discovery that these representations were in fact false. So State Auto moved for summary disposition, arguing that there was no genuine issue of material fact, that his statements in the application for benefits were false, thereby triggering a fraud exclusion in the insurance policy under Bahri versus IDS. It also argued that the intervening provider, Dr. Zamorano's claim, should be dismissed since the doctor's entitlement to benefits depended wholly on Pitts' entitled to benefits. And since Mr. Pitts committed fraud, he was not entitled to benefits, and therefore the provider was also not entitled to benefits. The trial court granted summary disposition in favor of State Auto. However, the Court of Appeals reversed. The court focused on whether or not Pitts' intent to defraud was present when he made the representations on his application for benefits. An intent to defraud is not shown where a false representation is made as a result of inadequate memory, unintentional error, confusion, or the like. And that comes from the case, which is a published decision of Mina versus Star Indemnity Company, a 1996 decision that allows plaintiffs to argue against fraud. They can say that it was a mistake, that they didn't remember, or that the error in and of itself was unintentional. Most of the time, though, from a practical standpoint, the court does not let that happen. They look closely at whether or not there was the misrepresentation, and you can make the arguments that it was intentional. But here it was a little different. Pitts explained in his deposition that while he treated her for back pain before the accident, the condition was actually misdiagnosed as a back injury when it was really an artery disease. So that's why he said that he did not have back issues before this incident. He also explained that while he treated for issues involving other body parts before the accident, that the accident made them worse, meaning that the symptoms he treated for following the accident were different from those that he treated with before the accident. Pitts also claimed during his deposition that the placement of questions on the application confused him, and he believed that the questions about workers' compensation benefits and Social Security benefits were questions in relation to the present accident. So in other words, he thought that when the app for benefits asked if he applied for Social Security disability, he believed that they meant after the motor vehicle accident. Same with his workers' compensation. So all of that was explained at his deposition and was on the record. In looking at all the testimony as a whole, the court determined that in order to prevail on a theory of material misrepresentation, the insurer must prove not only that the swearing was false, but also that it was done knowingly, willfully, and with an intent to defraud. In light of the above evidence, and in light of the testimony that was gathered throughout discovery, the court determined that granting summary disposition was a mistake and remanded for further proceedings. Now, this case is important because the testimony of the plaintiff is really going to be key at the motion for summary disposition hearing. And even though you believe that they did make misrepresentations in the application for benefits, they might be able to persuade a judge that it was something to do with the misleading application, that they didn't understand the question, or that they put down an answer that is being misinterpreted by the insurance company. So this person saying that they treated for issues that were worse after doesn't mean that he treated for the same or similar conditions before. All of that is important to bear in mind when you're reviewing an application for benefits and when you have a case in litigation and you're assessing the likelihood that a motion that your counsel is filing is going to be granted. You want to actually review the testimony itself as a whole and make that determination in your claim handling. The next case from the Court of Appeals this month is the Willis versus Doe case, and this case involves constructive ownership. It goes through a very nice analysis of whether or not someone is a constructive owner and what exactly that means. So in Willis versus Doe and Progressive, the Michigan Court of Appeals reversed the trial court's order granting summary disposition to defendants, Matthew Fodal and Progressive Insurance Company, holding that there were facts that allowed for a reasonable inference of constructive ownership of the vehicle involved by the policyholder. Here, plaintiff Willis's vehicle was struck by an unidentified driver of a motor vehicle. He was injured in the crash and sought benefits via a no-fault insurance policy issued by Progressive for his vehicle. The policy, however, was purchased by plaintiff's live-in girlfriend, Miss Davis, and the plaintiff was only listed as a driver on the policy. After uncovering this information, Progressive refused to pay for plaintiff's benefits under the policy, resulting in plaintiff filing a first-party claim for no-fault benefits against Progressive and a third-party negligence claim against the defendant tortfeasor. The Progressive defendant immediately moved for summary disposition and asserted that plaintiff failed to maintain no-fault insurance on his vehicle as required by the No-Fault Act, specifically MCL 500.3101. Therefore, his claim was barred, and the tortfeasor also moved for summary disposition, arguing that because plaintiff failed to maintain automobile insurance, his third-party claim was barred as well. At the trial court level, plaintiff further argued that even if Barnes versus Farmers required the no-fault policy on the vehicle to be procured by the owner of the vehicle, Miss Davis was a constructive owner of the vehicle and insured the vehicle. The trial court, in granting summary disposition in favor of the defendants, concluded that an owner of the vehicle must procure the policy, and they were not persuaded that Miss Davis was a constructive owner. However, the Court of Appeals disagreed. On appeal, defendants Progressive and Fodal again argued that plaintiff was the sole owner of the vehicle, as plaintiff testified that he was the vehicle's primary driver and Miss Davis was the primary driver of a different vehicle in the household. So she had her own car and he had this car. In addition, the plaintiff testified that when he purchased the vehicle, Miss Davis was a co-signer on the loan, but that he alone made the monthly payments. She did not contribute to the payments on the vehicle. Finally, plaintiff testified that one of the sets of keys for the vehicle were left at the home he shared with Miss Davis, who had driven the vehicle before, without elaborating on the extent of her use of the vehicle. Plaintiff contended that Miss Davis was a constructive owner of the vehicle because in her sworn affidavit, she affirmed that she had access to the vehicle whenever she wanted to drive it. She also had a set of keys to the vehicle in her home and access to the keys at all times. In addition, she did not need to ask plaintiff for permission to use the vehicle. Finally, she paid for service on the vehicle. For example, she paid for oil changes, she paid for fuel. She had driven the vehicle on numerous occasions, and the vehicle was generally garaged at her address. Based on these facts, the Michigan Court of Appeals reversed the trial court's decision. The court found that because the vehicle was purchased in 2014 and the accident occurred in 2016, this allowed for an inference that Miss Davis could and did drive the vehicle without needing permission for a period of greater than 30 days. Moreover, given that Miss Davis had free access to a set of keys and performed maintenance on the vehicle, a fact finder could reasonably infer that her use was proprietary or possessory rather than incidental. These facts allowed for a reasonable inference that Miss Davis was a constructive owner, and the trial court erred by granting summary disposition. Notably, although the court reversed the decision of the trial court, they did not enter an order in favor of plaintiff. Instead, they found that this type of analysis must be sent to a jury because they had competing information that were both taken under oath. They had the sworn affidavit of Miss Davis, and then they had the plaintiff's testimony, which seemingly tipped the scales in favor of defendant. But nevertheless, they determined there wasn't enough there to make a definitive ruling about ownership and entitlement to benefits. Therefore, the case has to be submitted to a jury to make that determination. Finally, we have the cases that were decided by the Michigan Court of Appeals pertaining to provider suits. These were all issued on September 18th, 2018, and they involve 3 different carriers, Allstate, Hastings, and Esurance. I'll just go over generally what they argued in the cases and what resulted in each case. So in all 3 cases, the insurer moved for summary disposition based on the provider's lack of standing to sue under the No Fault Act post-covenant. In all 3 cases, the providers claimed that they had standing on the basis of assignments that they received from the injured claimants. We all see those all the time. The assignments are now typically attached to the complaint. In the case against Hastings, where the insurer was represented on appeal by our firm actually, the provider filed the suit after covenant and therefore attached the assignment to its complaint. However, in the other 2 cases, the providers sought leave to amend their complaints in response to the insurer's motions to add their theories of recovery based on assignments. In the case against Allstate, the trial court denied the provider's request for leave to amend its complaint on the grounds that because plaintiff did not have a direct cause of action, plaintiff had nothing to amend or relate back to. But the appellate judges found that although the claim as originally pled was clearly subject to dismissal under covenant, the trial court also failed to properly consider whether leave to amend the complaint should be granted. Therefore, the case was remanded to the trial court for consideration of whether amendment to assert the claim under an assignment of benefits theory is proper in the present case. So in light of those considerations, the Court of Appeals sent that back to be determined by the trial court. Now, in the case against Hastings, the Shaw case that came down, Shaw versus State Farm, which determined that anti-assignment clauses and policies are void, was a consideration in those cases. In Michigan Head and Spine versus Hastings, Hastings relied upon anti-assignment language contained in the policy that it had issued to the injured person. The trial court agreed that this language invalidated the assignment, leaving the provider without standing. However, in the Shaw case, a precedentially binding decision, the case rules that an anti-assignment clause in a no-fault policy is unenforceable to prohibit an assignment that occurred after the loss or the accrual of a claim for payment. And the reasoning behind that is because a prohibition of an assignment violates Michigan public policy that is well-grounded in common law. So the holding compelled reversal, and the panel rejected Hastings' invitation to declare a conflict with Shaw. So the case was taken all the way to the Court of Appeals to get the court to assess Shaw and to determine whether or not we can still make these arguments in light of Shaw. And they did not want to do that. They said we will not determine to declare a conflict with the Shaw case law. Similarly, in the case against Esurance, the insurer relied upon the anti-assignment language contained in its policies. When the providers in that suit moved to amend their complaints after covenant to assert the assignments, the trial court found that such amendments would be futile in light of the policy language. Again, the Court of Appeals held that this was incorrect because under Shaw, the anti-assignment provisions in defendants' policies are void as against public policy and present no obstacle to the provider's claim under an assignment of benefits theory. So as was the case in the Allstate litigation, the panel in the Court of Appeals found that the claims as originally pled were subject to dismissal under covenant. However, the trial court needed to go further and consider whether amendment to assert a claim under an assignment of benefits theory is proper in the present case. So what do these three cases mean, and how are they relevant to where we stand in this post-covenant world? Well, they're relevant certainly because of the fact that they look at Shaw and they look at how to analyze the case law and the claims in light of Shaw. And here we have a Court of Appeals decision, albeit unpublished, but still gives you an idea of the temperature in the room here, that they're going to continue to apply Shaw and they're going to not allow the carriers to apply the anti-assignment provisions in their policies, deeming them to be void as a matter of law. So as promised, I'm here with my colleague, Aleasha Hester, who handles a lot of fraud cases, and she's going to talk to you about claims handling and identifying fraud early on and what you can do to further investigate fraud to assist in the furtherance of the claim and the investigation that obviously assists us while in litigation. Hello, Aleasha.
Hello, Javon. How are you?
Good. Thank you for joining us for my PIP Monthly. You do a lot of fraud cases. I'd say more than half of your cases are probably fraud-based.
If not more, yes, you're correct. Probably about 90% of my cases are all fraud-related. So I work closely with SIU agents as well as adjusters, obviously, from pre-lit through litigation of fraud and other styles of SIU work. It's really surprising to me the amount of fraud actually that occurs with auto and premises in Michigan. There's a lot of different things that are set up to deter that from the underwriting process. However, once it gets past that, a claims adjuster kind of is sitting there going, now what do I do? Or how can I confront this from my position? And working together with either their SIU team or working with an attorney from another office regarding the processes or the tools that are available for them, there's this wide array of what actually truly is available. And a lot of it can be very specific to the case. However, there are some basic beginning tools to kind of start digging to find the fraud. Everybody leaves a trail, no matter what they're doing, whether it's through fraud in the procurement of the policy, fraud in the claim process, there's a trail that can be found. Every person every day kind of leaves their own trail. Stop for coffee this morning.
Use your debit card or your credit card or something.
Had to get gas.
Again, use your credit card.
So there's this little trail that we leave everywhere. And we're also, did you use your phone?
Yeah, absolutely.
So using your phone as well, we can use cell phone records to kind of track where people are at. We can locate where they were before an accident, after an accident. Or, again, maybe they're making a fraudulent claim that we're trying to track to see if it truly was a real injury. So for a adjuster to gather the information to help them, one of the first places they usually turn to is a recorded statement. So with the recorded statement, there's a lot of information that can be gathered. Before they go into the recorded statement, the preparation truly is the key.
What kind of things do you recommend someone would have before they even strike to initiate the recorded statement or ask either SIU or their counsel to do that?
So obviously looking at each claim a little bit differently, you're going to want to know what type of issue you're looking at, right? Just discovering that initially. Is it a garaging issue? Is it a commercial policy issue? So that's the very base of where you're starting, correct? Then from there, you can gather documentation. There's so much information that's out there about all of us that is free to the public.
Yeah.
It's kind of crazy, but it helps with a lot of things. So for example, you can get bankruptcy records. You can get divorce and marriage certificates. You can get friend of the court records. Now with all of those, they are sworn statements. They are under penalty of perjury. They're something that you can use pre-suit and through litigation as well in defending a claim, especially for garaging. The residency address is on all of those. Bankruptcy gives you a little bit of insight of maybe this is why they're making this fraudulent claim. It can allow you to dig a little bit deeper. So like I said, the preparation is very important. For example, when you walk into the recorded statement, you're trying to discover why. Why are they doing this? There's always a why behind everything, correct?
Right.
We might not always get that answer in life, but in fraud, you usually can find it. So with the fraud, the why behind it for most people is there's another relationship going on that they're hiding. There's a gambling problem going on. They have an addiction problem. So bankruptcy, one of our biggest triggers that we can find out immediately, but it also leads to those questions that you can ask during a recorded statement to try and kind of uncover the why. Now, again, with the documents that are available from a commercial policy perspective, LARA documents are on the Michigan website. You can download them easily. It gives you information regarding the address of the company, the registered agent. So now I have a contact of someone I can get a hold of. And then also kind of leads you to another path of surveillance. I know where I'm going. Also tells you what type of business it is.
And sometimes it probably conflicts with what they're actually holding it out to be.
Exactly. For example, I had a claim in which I had somebody driving a Cavalier, Chevy Cavalier, small vehicle, and they were putting out there that they had this painting business. Could be legitimate, right? You can put a paint can probably in the back of the car. There's some room. However, a commercial business, generally with the Cavalier, you're probably going to want a van. You have long sticks and poles that you're usually using. You usually have a lot of different products, and you don't want your paint cans flying all around in your back of your car. So you're usually going to see a truck or something along those lines. The vehicle type can give you a big head start on, is this possibly fraudulent?
So if someone is listing that they have this painting company, but the vehicles are a bunch of sedans, that should probably raise a red flag.
Absolutely. Absolutely. This also gives you a head start, and into the next area of it is social media. So for adjusters or attorneys even to look up, social media has become such a big thing for our society that we are freely sharing where we are, what we're doing, who we're hanging out with, and on so many different platforms. There's several different that are available. And a lot of people will leave this information public. Therefore, one of the biggest things that this can be used for is for a threshold claim. So in McCormick v. Carrier, we have to make sure that there's a serious impairment of body function. If I'm following somebody or somebody is making a claim regarding this injury or an impairment on their life, how it's changed their life, yet I pull up their Facebook and I find a video of somebody who's claiming to be in a wheelchair, yet they have a video of them MMA fighting in their front yard with their kid.
I take it that's coming from experience?
It may be coming from experience. I've seen a few of these things. It's so surprising every time. Yet you find videos like this that are on there. You find pictures like this that are on there. Another example would be somebody making a claim like this in their whitewater rafting.
Right.
It's people, I guess, don't understand. We're learning as a society that a picture on the internet is everywhere and anywhere, and somebody will find it. So social media is a huge tool for adjusters and attorneys to use to discover this fraud in the procurement of the policy, potentially with where they're located or their business even. Maybe they have a Facebook page for that, but more so for threshold injuries.
Right. And just to add to that, I mean, you can also check with state records. Did the person get a hunting license this year? Did they get a fishing license? If they're a runner, you can try to do some Google searching and see if their name comes up in any recent races. I actually had a woman claiming a 24/7 attendant care claim, and then come to find out she ran the Disney Princess marathon in Florida. So that case was dismissed, but ultimately because we were able to find that she was continuing to run despite these alleged impairments. So there's so many forums you can check to see if this person is active. There's a golf association, there's a bowling league, there's all kinds of websites that you can find names and registration of these people. If you even just start off with a Google search, it will take you somewhere.
Additionally, like I had stated as well, the location check-ins on social media. So you can find out, people check into these races and they post it on their social media.
It's a very proud moment. So I'm sure they're capturing that and sharing it on social media.
Absolutely. Additionally, with that, when you get a little bit deeper into litigation and you can start doing subpoenas, you have messages and metadata that is all included in all of your social media. And with that, you can see if somebody is deleting a post or hiding something that once they filed suit, their attorney is going, it doesn't look good, let's take it off. Well, I'm sure an attorney wouldn't state that. However, the plaintiff may claim that. So moreover, when you're going through, so we discussed, all these documents that you can find, you have your social media that helps, but also surveillance. Surveillance is a huge tool and it helps uncover so much. And there's different types of surveillance that are available. There's mobile surveillance where they're following somebody. It's probably the most basic that everybody knows. You have the covert surveillance where I have an investigator shopping side by side next to you in a grocery store, or they're possibly even working with you. And then we have stationary cameras. Stationary cameras can be extremely helpful, especially in situations where an investigator could be discovered very easily, such as mobile home parks and apartment buildings. It gives you a camera there at all times to kind of see what's going on, where your plaintiff or claimant is going, or who's coming to see them, which also leads into exploiting the attendant care or replacement services. Generally, the adjuster will immediately get the name, phone number, address of who's helping them, whether it's through attendant care or replacement services. They know the address of where they're at. We can follow from point A to point B of getting to plaintiff's house or claimant's house and seeing, are they consistently going there as often as they're stating? Are they visiting or staying or helping for as long as they say that they are helping? That's probably one of the easiest things to uncover through surveillance. Another is employment. So a lot of the times what we'll find is while they're making a wage loss claim, they're still working under the table somewhere. And you really don't discover that unless you see them. That's not something paper trace wise that we're necessarily going to see. That's definitely going to be something I'm going to need an investigator out there to discover.
Right, to see if they're going there multiple days in a row and staying for 5-8 hours at a time.
Absolutely.
Right.
And a lot of the times with that type of surveillance, you find them at night working. They work odd shifts. So that's another tool for adjusters to use when they're determining, because you can limit how much surveillance you're doing or the amount of time that you're putting into it and make your scope very small. If you know what you're looking for, then you start uncovering all these questions of who, what, where, when to make your surveillance worth it. Further, with commercial business, I think that's the biggest one with this. The biggest thing with commercial business policies and fraud is, are they using it for a legitimate business purpose? And a lot of the times, like we said earlier regarding the LARA documents, you're going to discover what type of business it is they're using it for. Also on the policy, it should be stated to the adjuster. One of the biggest things that adjusters have in fraud in the procurement of a policy is the recorded statements that are made with any of their customer service reps of when they initially take the phone call to start the policy, or a lot of insurance companies have their application process over the phone or online, followed up by a phone conversation that is recorded. It's a great tool and used heavily in several of our motion for summary dispositions as a statement made by the claimant or plaintiff regarding the application of the policy. So with that, once you discover what kind of business that they have, surveillance, you can follow around and see where they're going or what business places they're going to or where they're shopping for tools. You're also going to be looking on their vehicles, finding out if there's any decals on their car. Could a decal on a car mean that they just placed a decal on there and they're not really using it for a business? Absolutely, but that's why you dig a little bit deeper. Everything has its outside shell of exposure, but the inside is when you get to the good stuff. It's like a peanut M&M. So with that also, we talked about the size of the vehicle and the tools that they're using. A lot of the times, something else to discover in documentation and surveillance is maybe they have a storage facility and they're keeping items there, keeping their tools there, or it's kind of their place of business of holding. So they're holding all of their equipment there, so they're going back and forth. It's an easy way to discover if they truly are operating a business that's legitimate for the commercial policy. So to wrap it up, there's just a lot of information that can be discovered through surveillance, and if you know specifically what you're looking for or digging very intently into a specific area, there's a lot of questions to be asked and tools specific use for those to help you discover this fraud. So as we said, we have surveillance, social media, the recorded statements. Additionally, with the recorded statements, I think the biggest thing, even adjusters talking to their claimants, they call still until they're represented. You can continue to ask these questions. Everything is a conversation with your claimant or plaintiff. And when people are comfortable in a conversation, that's when they start to give information that maybe they don't really recognize that you're asking a question. So for example, when you're trying to discover the garaging issues, it's the location. So where are they at? Where are they shopping? Ask them what's the closest restaurant they go to, or where do they frequent often. These are great little tools or little questions that can be popped in any place, whether it's a recorded statement or a conversation over the phone, that'll help any adjuster or attorney discover fraud in the claim process or procurement of the policy.
Well, Aleasha, thank you so much for your insight about fraud. If any of you have any questions about what was discussed here today, feel free to contact Aleasha. She's our little fraud expert over here. So that's all for this month's My PIP Monthly. We appreciate you spending your afternoon with us, or evening or morning if you're listening to it on your iTunes. And we'll see you next month.